We wait to resume the examination. The Secretary brought to my attention that during the course of the proceedings there have been sort of various offers or undertakings to provide lists and documents of varying kinds. I gather that the treaty we ask about has now been put in, but as I recall, claimants are going to put in a legal authority on a legal provision relating to who determines or plays some role in the determination of boundary disputes among rural communities, and respondent was then going to put in a subsequent paper listing other authorities they thought might be appropriate. And I'm sure there's some other things of a similar ilk, but I would ask you to check your memory banks and see what it is you may have committed to provide, and we will do the same. And to the extent we are still missing some things, we will in due course bring this to your attention. That said, are we ready to resume the cross-examination?
Yes, Mr. President.
Okay, and are we ready on the reporter's end? Yes, ma'am. All right, interpreters. Okay.
Let me remind you that I have a pending question about social license. So whenever you finish the topic, let me know.
I know, sir. I will now leave the topic of social license and discount rate, and we'll actually come to social licensing in the cash flow. So if your question relates to social licensing and discount rates, that would be the... Okay. Now, Ms. Kunzman, Mr. Lee, let's turn to how you have modeled the costs for acquiring and maintaining a social license in your reports. Before doing so, just to check, you're aware that IMC has signed agreements with Laxongo and the Santo Domingo communities, right?
Yes.
Okay. And the SRK mine plan included 1.2 million of capex related to community infrastructure and 3 million of ongoing community relation costs. Are you aware of that?
Yes.
Okay. So would you agree with me that the mine plan already includes the costs for acquiring and maintaining a social license from Laxongo and Santo Domingo?
Yes.
Okay. The allowance is actually a bit larger than what Laxongo and Santo Domingo have asked for, right?
Up to now, yes. But I understand that what we show in the table, it's just what they asked for in cash, but there are also some non-cash items that they asked for.
Okay. Now, you were referring to a table. Let's go to that table. I think it's Appendix 5 of your second report. Is that the table you were referring to?
Yes.
Okay. Now, just for the benefit of the tribunal, in this table, you are calculating how much the social license would cost for Paran, right?
It's a rough estimate, yes.
Rough estimate, okay. Now, let's look at what you did here. If we look at the top, we see...
Counsel, excuse me, is this in the binder? Because, of course, it doesn't appear in the version here.
The problem is it is an Excel spreadsheet.
Okay.
And
all right, we'll put on our glasses and take a look.
we can, I mean, you can operate, if you prefer, because the figures are the same, you can operate out of figure 13 on page 33 of Alex Partner's second report. I'm just referring to the Excel spreadsheet because it contains underlying data, and I would like to take the expert to the underlying
No,
data.
that's fine. Thank you.
So, at the top we see what you call Peron original agreement, which is some 322,000 soles, right?
Yes, and if you don't mind, I'm going to pass on these questions
Sure.
to Mr. Lee.
324,000, yes.
Yes, and that would be roughly 96,000 US dollars.
Yes.
And this forms part of your Peron past request, which amounts to roughly 1 million soles, right?
Yes.
And if we go to the Documents Review tab, we actually can see that the amount, the 324,000 soles, comes from the Exhibit C60, C61, and C62, correct?
Yes.
But these are amounts which Andean agreed to pay to Peron, not IMC, right?
I'm not certain about who the payor was, but the purpose of this schedule is to forecast what a social license cost could be in the future. Historical payments were just one of the things that we used to base that on.
These are historical payments from 2008 and 2011, correct?
These are historical agreements. I'm not certain about when they were actually paid.
Okay. At that time, 2008, 9, 10, 11, the concessions that Andean was looking at were on Peron land, right?
Are you referring to the previous design of the project?
Yes.
I believe that, yes.
Peron never requested these amounts from Lupaka, right?
If you mean they didn't sign that agreement with Lupaka?
No, they never requested the 24,000 soles from Lupaka. They requested a different amount from Lupaka, correct?
They made other requests to Lupaka at different points, yes.
Yes, the ones that you see in the next line. Going back to the summary, they actually requested 700,000, not 324,000 soles from Lupaka, right?
Right, so the purpose of this schedule, again, is to summarize all of the past requests made by Peron to whichever entity was in control of the project at the time.
And you would just add them up irrespective of whether Peron asked them from Lupaka.
In this schedule, because we're conducting an illustrative example of what that cost could be, we're not people who can estimate it with any kind of clarity. We took all the historical amounts and added them up as an indicative amount.
Okay, can we agree that Peron asked from Lupaka 700,000 soles, which is roughly 207,000 US dollars?
Yes.
Now, if I go back to the summary tab, to your scenario 1, to these payments, the previous requests, you actually add another one-time payment. Just for me to understand what you're doing, you're calculating an average between Laksanga's one-time payment of the one-time payment to Laksanga of 210 and the zero that was paid to Santo Domingo, right?
Yes.
And the Laksanga one-time payment refers to actually the construction of a tap, a water reservoir, and national festivals, right?
I believe you're showing me now on the page.
I mean, it's your.
I think it's the one-time ones only. Yep.
Peron never made those requests to Lupaka, you agree?
They
The
never
request-
made. Sorry, don't understand your question. They
These are
never-
requests from Laksanga to Lupaka, not from Peron to Lupaka.
Correct, and I think on the previous summary schedule we note them as Laksanga requests.
Yes, so they shouldn't be included in what Peron is asking for, should they?
So we were asked by council to estimate this based on the requests made by Peron, Laksanga, and Santo Domingo as a estimate of what the social license would cost.
So, so you added all the figures you can find together to get the maximum number, even though Lupaka has already paid some of these amounts to Laksanga and Santo Domingo.
I wouldn't characterize it like that. We took the information that was available in the record to try and estimate what the social license would cost.
The social license from Paran,
From Peron specifically.
And you added demands from Laksanga, even though Peron's only asked for 700,000 soles up front, correct?
Correct. Under the understanding that Peron might request more based on what other communities received.
Now, let's have a look at paragraph 115 of your second report. That's on page 33.
I see that.
So you describe what you have been doing, and I think what you have explained here, you say that you accounted for a one-time payment of $300,000 and then an annual payment of another $300,000 for 10 years, correct?
Correct.
And that's based on the average payments made to Laksanga and Santo Domingo.
Correct.
And you say that the net cost is around $2.4 million.
On a standalone basis, assuming 10 years worth of payment, yes.
Yes. Now, when you say you calculated these costs on a standalone basis, what does that mean?
So if we only made this adjustment, the net impact that we calculated was $2.4 million. So no other adjustments that we discussed in the report.
But you're also ignoring the impact of these costs on working capital and taxation, aren't you?
I think that they flow through the model. We add them as an operating expense.
That wouldn't make sense, sir, if you just look at the figures. 10 times 300,000.
Mm-hmm.
You discount that. You take off 30% tax. That would give a lower figure than 2.4 million, wouldn't it?
Could you show me in the model?
I cannot. I just have to put it to you. Accuracy has calculated it. But let's take 3 million. 3.3 million. Take away 30% tax. You would end up at 2 million, right? It's an impact on the NPV without even discounting it, wouldn't you?
I think Isabel has
Yeah.
input on this one.
We can't make these calculations like that on the fly here. It's a calculation that Accuracy has presented in the hearing presentation. So we would need to review that calculation. But we're happy to show you in our model how we toggle the model to say whether these are included or not, and how it flows through the discount rate and it flows through the taxes. But yes, we're not prepared to discuss in such details without Excel in front of us.
Okay, but you would agree with me that if you were assessing the impact on the NPV, this would have you would have to take into account the post-tax effect of the social licensing cost, right?
And that's how we did it in the model.
Now I will move to another topic, Mr. Garibaldi.
Thank you very much. I have difficulty understanding all of this.
Okay.
Because for the following reason, that you purport to calculate the cost of obtaining and maintaining social license from the Paran community on the basis of what they asked in the past and maybe an average of what it being paid to the other communities. But there is one factor here that is missing, and that is that the other communities did provide what you call social license. The Paran community did not. So the amounts that they received, the amounts they asked for, were obviously not enough to provide a social license. That's one problem. The second problem is that there is evidence that we have seen to the effect that in addition to these payments, the Paran community wanted other things like 10% of the profits of the mine, like suspension of operations of the mine. It claimed to be expropriated, and ultimately they wanted to operate the mine themselves and did operate the mine themselves. That's the second problem. The third problem is that we have heard testimony here, an argument to the effect that there are really no limits to what the Paran community can demand in exchange for granting social license. So, in essence, here you are trying to calculate something that could be an infinite number. And I say infinite, it's not exactly accurate because it's sufficiently high number so that the company goes bankrupt or abandons the mine. So since there are no limits to that, and the community of Paran is not obligated in any way to grant social license in exchange for anything, it's up to them to make whatever demands they want and to keep on making demands for maintaining that social license. So I don't know how you can calculate it.
Okay.
Yeah.
So, yes, this, on the first point, this is just an estimate based on the assumption that Paran community would ask for something similar to what the other communities had asked. You are absolutely right. That there is no guarantee that that would have satisfied them. We're just running the numbers in case the tribunal thinks that makes sense.
Excuse me, but it's not a question of guarantee. We know that it didn't happen.
Okay, then I wouldn't rely on those calculations, and that is why we call the social license risk a fundamental flaw at the beginning, in that there was a chance that they wouldn't get it.
All right.
Yeah.
Yeah, but isn't it unquantifiable?
It is based on the data that we have. Yes, it's very hard. But they did get the social license from the other two communities, and then based on the valuation from KPMG or PwC, I can't remember right now, they assigned a value to the mine of 13.4 million once with the blockade and everything. So, like Mrs. DeFore testified, it is an issue of time, right? Maybe they could wait, or maybe even if they waited, it wasn't going to happen. The investors have three choices, right? Wait, walk out, or sell. So if it was an issue of the specific to Lupaka, then maybe there was still fair market value. But like you said, getting the social license from Paran could lead to the project being worth zero. And we would need to, if I had access to all the information, it would be an issue of understanding from the community and understanding from Lupaka what could still be done from a valuation perspective. How much would it cost, and if, based on what that cost, if it would still be profitable to run the mine. I mean, but this happens all the time in businesses. Think of it, for example, with unions, right? They want to get paid as much as they can, but you also have to make them understand that you reach a certain point where, because of what they're asking, the business is no longer profitable. So any benefits they would get from the business, they would stop receiving. So part of getting a social license is doing that. And we have a list of what's recommended, and one of them is understanding some of the benefits.
It's not the same situation, because unions are subject to legal constraints, mandatory mediation, mandatory negotiation, all those sorts of things. Here we have nothing. There is no constraint here, according to what we have heard.
Right, it's a much higher risk.
It is entirely up to the Paran community to say yes or no, or how much price they want to be paid for it.
Right, so the onus is on the investor to try to convince the Paran community, like they successfully did with Santo Domingo and Laxanga, that there is a benefit for them. They were able to do it for two of the communities, just not the third one.
Well, I can think of other possibilities, but that is not the area of expertise. So that's my question. Thank you very much.
Thank you. Now maybe just before I continue, Ms. Kunzman, on what you've just said right now, it would be, let's try to model this as an economist, what you've just said. So it would be rational for the community asking for a social license to ask essentially as much as the profit made by the entity that is holding the prospective mine, because that would be the break-even point where it wouldn't be worthwhile anymore for the mining entity to go ahead with the project, right?
Not the profit, it would, because investors have a required rate of return, so you would need to account for a required rate of return on top of the profit.
But up to that point, a rational community, if it's right what you are saying, would be able to siphon off the whole profit, because if it's correct what you're saying, they could demand an amount up to the point where it wouldn't make a difference for the investor or for the mining company to walk away or continue with the project, correct?
They would still make their required rate of return. But yeah, at some point, and that's the issue, communities have that power. But that's why companies often employ people from those communities. They train them. They provide profit sharing. In Peru, you have profit sharing. So you absolutely have to convince the community that there are additional benefits to just cash payments.
But why would they walk away with just a few classrooms and community programs if they can have the full 41% of the NPV that here in this case Lupaka would have generated with the project?
I cannot evaluate what a community might value more. Some communities may value training more than cash. I don't know. I don't know this community.
But if what you're saying is right, they could ask up to 41 million and they would be in the right to ask up to 41 million, and they would be silly if they didn't ask up to 41 million US dollars for this project, correct?
No, because the other communities didn't do that. They saw other benefits besides cash.
Because actually the concept of social licensing doesn't allow you to ask unlimited amounts, does it?
The concept of social license is not about its acceptance from the community. You achieve that acceptance through various means. Like I said, some of them are providing employment, providing training, providing education, providing roads, many ways. It's not just a cash payment. And also sharing the benefits of the project by issuing participation for your workers like they do.
But if the community had an unlimited right to demand a social license, they would be silly and irrational if they didn't ask for 41 million, correct?
Like I said, I can't make that assessment because I don't know this specific community. I don't know what's important to them.
And if they could ask up to 41 million for the project, that would be a complete expropriation of the project, wouldn't it?
First of all, the 41 million, you're saying that's the valuation, the 41 million? No, they wouldn't ask for 41 million because then that wouldn't cover the rate of return. So, but I don't know. You used a legal word that I can't opine on.
Okay, let's move topic, and discuss the impact of a delay in the production start date. Let's look at paragraph 70 on page 22 of your second report. Here you say that these missing approvals would have, and I think you refer to regulatory approvals, would have prevented the claimant from exploiting the project until July 2020, correct?
Yes.
Okay. Now, I'm not going to discuss with you what the correct production start date is, since you're neither a technical nor a regulatory expert. But let's try and agree on the impact of a delayed starting date on the project's value. Now, if I move on in your report and go to paragraph 87, you come to the conclusion that revising the production start date from November 2018 to July 2020 would reduce damages by 8.7 million. Is that right?
Yes, that's what we say.
Okay, so you calculate a reduction of 8.7 million for a 20 months delay, right?
Correct.
Now, I know it's a very rough approximation, but would it be fair to say that the reduction of damages per month is around $435,000 on average?
Yes.
So let's assume for a moment that the tribunal came to the conclusion that neither the claimant's production start date of November 2018 nor the respondent's start date of July 2020 is realistic, but that in a proper but-for scenario, the production start date would be somewhere in between. Now, can we help the tribunal in the sense that they could get an approximation of the damages by reducing the damages claimed by the claimant by approximately $435,000 per month in the 590 tons a day scenario?
If that was the only adjustment they were making, the problem is the discounting, right? So the reduction is greater the closer you are to the production start. But it would
Yes.
be an approximation.
It's an approximation.
Yeah, and it would, if that is the only adjustment. If there's another adjustment, they could be under or over compensating.
Okay, and if we give them a rough figure for the 355 tons a day scenario, I suggest we go to page 44 in paragraph 153 of your second report. So we see
Yeah.
a reduction in the net present value of some 6.1 million for 20 months.
Yeah.
So that would be approximately $300,000 per month.
Yeah, same issues, but yeah.
Okay. I'll move on. So if you are considering asking questions. Okay. Now, let's turn to your report, second report, page 28, paragraph 92. So you talk about Mycon's extended production schedule, right?
Right.
Okay, but you say again, we understand, and then you continue to say that you understand that this schedule was made just for the arbitration.
Yes.
Okay. Have you looked at Mycon's explanation for the extended production schedule?
I have looked at it, yeah.
Okay. And let me take you to the Mycon report at page 36. It's tab 9. In paragraph 111. Tab 9, sir. Now here Mycon say that, or explain that Red Cloud assumed a 6-year production period, similar to the life of mine in the PEA, but then that Mycon's review showed that there was potential for at least 8 years of steady state production. Can you see that?
Yes.
Okay. Now, if we go to paragraph 93 of your report, of your second report, sorry. On page 28, you say that Red Cloud's production schedule was created at the time that Lupaka was considering acquiring the Mai plant.
Around the time, yes.
Yes. And then you go on, and I'm struggling there when you say essentially that Red Cloud's forecast is therefore a more credible basis for estimating damages than, I quote, than the revised production schedule that Mycon improvised.
Yes.
Now, Ms. Consman, it's not for me to give you a lesson in the English language, but wouldn't the word improvised be more appropriate for an advocate rather than an independent expert? I mean, after all, you're not the technical expert.
I could have used another word. Yeah.
It just got carried away a bit, I assume, after rebutting so
Now
many
looking
cases
at it
for
again,
Peru.
I would have edited. No, that's not true.
Okay. But you agree with me that the Red Cloud model was based on the SRK PEA, right?
Yes.
And you do agree with me that the SRK PEA measured 2.5 million tons of measured and indicated resources in the Atenea vein. Can take you to the document.
No,
Let's
I trust
do that.
you.
Okay.
Yeah, it's fine.
And let's go to the Micon report, page 37, table 513. So in Micon's production plan, 10-year production plan, Micon only included 1.8 million tons to be mined, right?
Yes.
So that's only about 72% of the total indicated resources, right?
I trust you on that. Yeah.
1.8 then,
Yeah.
compared to 2.5, sorry. So there was potential for even further expansion of the production plan, right?
Yes. But that was known at the time the SRK model was put together and Red Cloud. So that didn't change yet.
So
Invicta didn't consider it at that time. They didn't model that scenario. It's not until this arbitration that they've modeled the scenario.
So in practice, I mean, you're not a mining expert, and tell me if you can't answer, but in practice, if production comes to an end and there is more resource available to mine, it would make sense for a mining company to extend the production schedule, right?
I don't know. It depends on how much it would cost to take out that additional resource and what prices are at that point. So I don't know. And it's not something that Invicta contemplated at the time. It's not until this arbitration that this model emerged.
Okay. Now going back to your paragraph 96 of your second report, on page 29, you then remove 3 years of productions on that basis that 10 years weren't contemplated at the time of the Red Cloud model. And you eliminate additional capital development costs and closure costs for the 3-year extension, right?
Right.
Okay, and then you arrive at the damages estimate, which is around 10 million lower than accuracies.
Right.
Okay. But in doing so, you leave everything else the same and only cut the production and expenses of the last 3 years, correct?
Correct.
Now, if a mining company planned to mine for a shorter period than the 10 years, it presumably would focus on the best material, right? It would focus on the best stopes and extract the better material in each block. Would you agree?
I would say that because of time value of money, you would always want to do that, to mine the most profitable part of the mine first, no matter what.
A mining expert may disagree with you on that, but if you mined the high-grade ore early, this would increase the cut-off grade, wouldn't it?
Yeah.
And there would also be additional savings compared to the 10-year mine plan in CapEx, since there would be no need to extend development out to the margins of the ore body, right?
These are all very technical questions I can't answer. Ideally, the MICAN report would have been submitted on the first round, we would have made this observation, and they would have adjusted their model to 7 years or what, and they would have explained those issues. We're just making an observation that they extended it by 10 years, and this was the best way we could approximate what it would be to take out the last 3 years. But again, because we received it on the second round, we don't know the answer from MICAN.
Okay, but can we agree that just cutting off the last 3 years is an appropriate way to calculate the the NPV of a shorter project?
I don't know. I don't have the technical expertise to answer that question.
Okay. Now, let's turn to interest. You agree with me that the FTA requires a commercially reasonable rate?
Correct.
And you agree with me that the commercially reasonable rate is not a risk-free rate, right?
Correct.
Now, you suggested US Treasury bills and SOFR as a suitable replacement for LIBOR, right?
We said the tribunal might want to consider those two because LIBOR is being decommissioned. Is that right? Yeah.
I mean,
No,
it's your
decommissioned, that
testimony.
it's going away. I don't know if saying decommission is the right word, but LIBOR is going away. So we said you might want to use SOFR or US Treasury, which other tribunals have done as a to award a commercially reasonable interest rate.
okay, let's go to the accuracy presentation of this morning. It's slide 54 at tab 49.
Do we have
I
it?
don't think it's in a tab, I'm sorry. But you got the presentation this morning.
Oh, thank you.
Slide 54.
54? It goes to 48.
39. Sorry for that. Sorry for the confusion. Now we see here a comparison of LIBOR, SOFR, and 1 year US Treasury bills, right?
Right.
And we can see the movements of all these rates between August 2021 and July 2022.
Yes.
Now, we can see that LIBOR and USD move more or less in parallel, but that USD Treasury bills is consistently below LIBOR, right?
Yes.
And SOFR is again consistently below US Treasury bills, right?
Yes.
And the way you would actually bridge the difference between SOFR or USD and LIBOR is by applying a spread to USD or SOFR, right?
Yeah, that's assuming that the tribunal considers LIBOR plus 2 to be the gold standard for awarding interest. They might consider USD or SOFR instead of LIBOR. I mean, the difference is that USD and SOFR are based on actual transactions, while LIBOR is not. They're based on estimates from brokers.
Okay, but to actually bring UST or SOFR up to the level of LIBOR, you would have to add a spread, correct?
Correct.
And looking at that chart here, I mean, I know it's an inexact exercise that we are doing, but it would make sense, towards 22, 23, to adjust UST by about 1% to get to LIBOR, and SOFR by about 1% in February 2023, but a bit more, 1 to 2% earlier on in summer 2022, right?
It depends on the period.
But around now, the 1% to 2% would seem about right.
The 2% seems high.
Mm-hmm.
1%.
1%, a bit more than 1%.
Actually, it's hard to.
Council, can you remind us what the acronym SOFR is for?
Yes, this is actually secured overnight forward rate. But I'm pretty sure our economic experts can explain it much better than I can.
Secure overnight federal or forward?
Federal rate.
Federal rate, okay.
So to adjust the USD or SOFR to LIBOR, somewhere between 0.75 to 1%, but we can calculate that easily.
At the current moment.
At the current moment, right.
But more before.
It depends how you define before.
Okay. More between May 2022 and November 2022.
I'm sure this chart has the underlying data in one of their appendices with the numbers, and it'd be simpler to just look at that and we can talk about exact figures rather than try to eyeball it here, because we actually don't have the grid lines either, so it makes it difficult. So
I know we have a difficult job, Ms. Kunzmann.
okay, well then my question is, I don't know.
Okay. Now, let's talk about inflation. I think in your second report, page 51, paragraph 183, you say that UST, SOFR, and LIBOR are market variable, market determined rates which respond to fluctuations in the market, correct?
Correct.
I think we've heard a similar question this morning from Mr. Bombassaro. Now, if we look at the accuracy table A61, and you can find that in accuracy second report, page 87, tab 6. If you're going by tabs, or if you have the accuracy port separate, it's page 86.
It's this, right? I'm there.
Yes, I'm waiting for the tribunal members.
Tell us again.
It's page 86 of accuracy's second report. Page 87, sorry. Which is at tab 6. page 87, sorry. Now, if we look at that table, we can see that in, say, early 2021, inflation was quickly rising well over LIBOR +2 or UST +2. You see that?
I do.
So would you agree with me that, at least over the last 2 years, inflation was significantly higher than UST +2 or LIBOR +2?
Yes, I have not been compensated for inflation on my money market accounts.
Now, there's no obligation by your bank to make you whole, right?
That's right.
There is an obligation under BIT to fully compensate. Well, you're not a legal expert, sorry.
I thought we were talking about the commercially reasonable rate. That's what I'm opining on.
Okay.
Whether compensating for inflation would be considered a commercially reasonable rate.
Yeah. Now, you would agree with me that awarding an interest rate of LIBOR or SOFR +2% would mean that the real interest rate is negative.
Yes. We've had negative interest rates for a long time now.
So Peru would have every incentive not to pay the award, as the amount outstanding would get lower every day in real terms, right?
I'm not sure Peru would make that calculation, and if that's the way that Peru would decide to raise debt, that they have simpler, less costly ways to obtain funding. I'm not sure through the delay of paying awards would be the most effective way.
Okay. Let's move on to page 88 and look at table A62. Accuracy have here plotted the comparison between inflation and LIBOR +4 and UST +5%, correct?
Yes.
You would agree with me that these two rates are more in line with inflation, right?
They're over inflation for a big period, from December 19 to February 22nd, but from February 20th, I mean, I think hold on. I think I misunderstood the question. Yeah, they're above. They're over it. In line, not for a period. I would say +3 would be closer.
But even
LIBOR +3 and UST +4.
But even at this nominal rate, the real interest would still be very low and at times even negative, right?
Which real rate?
The difference between interest and inflation. That's real interest rate, isn't it?
Right, like I said, real interest rates have been negative for a long time.
Okay. I think that concludes my cross-examination.
Oh.
Thank you. Any redirect?
Yes, Mr. President, and we'll be brief. Ms. Kuzman, early in the questions from counsel, he inquired about a statement in your CV indicating that your engagement in this case was to rebut the damages claim. Do you recall whether you disclosed in your first report the instructions that you received from Peru's counsel?
I do.
Could you point us to the paragraph where you disclosed those instructions?
Can you help me? It'd be quicker if you told me where it is.
Understand, I believe it's in paragraph 5, if I'm remembering correctly. Of your first report.
Yes. Paragraph 5 of my first report. That's what I give.
Paragraph 4, I'm sorry.
Okay. Yes. It says my specific instructions were accuracy. Sorry. Accuracy presents its opinions in an expert report dated October 1st, 2021, appended to claimant's memorial. Counsel asked us to review the accuracy report and offer an independent expert opinion on whether and to what extent its calculations correctly measure claimant's alleged damages as a result of the measures.
Thank you. No other questions.
Let me ask my colleagues, have any questions given?
With reference to investment arbitrations, investment treaty disputes, did I understand your evidence to be that, apart from one other matter, for respondents, Peru has been the only retainer that you've acted?
No, I've had Panama as well, one.
So
And
I said
then,
apart from one, yes.
oh, yeah, and then when I wasn't the expert testifier, I was retained as a junior member by several other countries.
Well, there's somewhat a difference between being retained as counsel and being retained as an expert. You cross a large gulf going
I
from one to
am
the
so
other.
sorry. I don't think I understood your question.
Well, it's one thing to be part of the team of counsel. It's another thing to be an independent expert when you have obligations not to your team but obligations to the tribunal.
Absolutely. My obligation is to the
Okay.
tribunal.
Could I ask you briefly to comment upon Part 8 of Accuracy's first report, where it referred to benchmarks, other indicators of the value of the report. What's your own view as to the use the tribunal may make as to references to benchmarks such as Accuracy refers to?
I don't think those are valid benchmarks. I explain it in my report for several reasons.
You don't use benchmarks.
No, I will use benchmarks, but those benchmarks that they used are not the correct ones to use in this case. But typically, if I'm doing a valuation, I would implement the 3 valuation approaches: DCF, market transactions, and publicly traded company multiples. But what you find sometimes is that you can't find a good comparable to the project that you're valuing. And then I would also look at prior transactions or internal valuations that were done outside of the dispute.
Well, what would you regard benchmarks as? A cross-reference for confirmation, or what other reference point?
No, I would actually adjust my valuation. I would treat a transaction or a comparably publicly traded company not just as a benchmark, but I might adjust my DCF valuation based on that.
Well, there seems to be a distinction between a reference point to adjust your valuation and a cross-reference in confirmation.
Yes.
As I understand your answer, you prefer the first and not the second as a use for benchmarks.
Correct.
Well, how can you regard that as a benchmark?
Well, you're right. It's not a benchmark. It goes into my valuation. It's another point. So I don't.
So I'm just trying to find out what your position is on these references to benchmarks in Accuracy's first report. Is your basic position is that they're No assistance.
There are no assistants, no.
Thank you.
But to be clear, you're saying there are no assistance because these particular, well, I'll use the prohibited word, benchmarks, for one reason or another were inappropriately calculated, reflect inappropriate comparators and so forth. Is that your view?
Correct.
You do not, as a general matter, object or criticize or question the fairly common practice of seeking a valuation utilizing different methods and then seeing how those stack up in relation to one another.
Different methods than the DCF?
Yes,
Yes, correct.
that is a common technique in your field of endeavor.
Right, and that's what I was saying, that I would actually take it farther. I wouldn't just consider it a benchmark, but actually more than that.
Okay. Is that, I'm curious, in your experience, is that how it's commonly done? Or is this a reflection of how you do the business?
It depends. It depends on what you're valuing, because you're applying fair market value, right? So what you're trying to do is what a hypothetical buyer and seller would do in that specific market. So if typically in a market investors use just DCF, then you might use just DCF. But if investors use the three typical approaches, then you use the three. If they use the cost approach, then you use the cost approach. It really depends on what you're trying to mimic, that hypothetical investor, not my personal opinion on how I would do it.
All right, thank you.
So if I pick up the President's reference, if one is seeking to make a reference by reason to market value, is that basically on the basis of what will a fully informed but not anxious buyer be prepared to offer to a fully informed but not over-anxious seller? Is that a fair summary of the usual test?
That are knowledgeable of that market, yes.
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 Now, if the claim is the business is valueless because of the action of the other party for which it is responsible, would you not then disregard the effect of market value that's been brought about by that alleged action? So I see your brow furrowing. Can I put it another way? If one assumes, this is abstracted from the present circumstances, that the business has become unmarketable, there's no market for it because of the action complained of that's rendered it valueless, so there'd be no market for the business. Should you disregard that aspect in seeking to find market value, or would you search for another method of valuation?
You would need to understand if the reason for the failure is particular to the owner or if it's particular to the business. If it's particular to the business, then rather than valuing it as a going concern, you would value it under liquidation, or orderly liquidation, or regular liquidation. That would still represent fair market value, but it would be a different premise.
Well, perhaps can I ask another question? If one were to assume, because of the action for which there's claims against the respondent, the business became valueless, how then would you find the value for quantum of damages?
You would need to remove the measures that are being alleged are in breach of the treaty from your valuation.
Has that been done in this case?
They've removed more than that. They've assumed that they would have obtained they would have been able to start production, even though for reasons unrelated to the measures, claimant would not have been able to start production.
Is that a rather artificial inquiry if the business is valueless because of the action of the respondent against whom relief is claimed? If you assume that the business is valueless, isn't it a somewhat artificial analysis to try and find value when it's worth nothing in a market?
Well, because the business lost value completely, assuming in the actual scenario, not because of the measures, but because claimant lost its shares. So if the tribunal finds that claimant losing its shares is not attributable to respondent, then the business would still have value, which is the 13.4 million that PwC estimated. But otherwise, yeah, it would be zero.
Well, I haven't finished yet. Well, let's abstract my questions away from the fact of these shares being valueless or having some value. If we assume that the claim to be compensated arises wholly from actions of the party against whom the claims are brought, were you saying that it would be somewhat artificial inquiry to inquire what's the market value of the business that's been made valueless by the actions that are complained of?
It depends on the timing of those actions. The business could have been valueless before those actions.
Well, can I make it a bit simpler? Let's assume the business has been expropriated. I'm not
Yeah.
saying anything about the circumstances here.
Yeah, okay.
The business entirely lost.
Yeah.
Isn't it somewhat artificial to apply the market value test, willing but not anxious buyer, etc., if it's common ground that the business is worth nothing, valueless?
I mean, you could still find a company that hasn't been expropriated that's operating in the market that's comparable.
Well, is it possibly more useful to go to one of these benchmarks that you reject? For example, if you can't estimate value any other way, go to sunk costs.
The problem with sunk cost in this case is that some of those sunk costs are quite old. And sunk cost, you may invest in a company and the value could be less than your sunk cost at the end.
But the assumption I'm asking you to make is at the end it's worth nothing because of the actions of the party against whom the claims are brought.
That you could still have your sunk cost.
It's
Yeah.
about all you're left with, isn't it?
Yeah, sunk cost.
If you started with something because of the actions one assumes of the party against whom the claim is made and is liable for breach of some treaty obligation, then isn't sunk costs a rational reference point?
Sunk cost would be a rational reference point, but I would be wary to use a very conservative interest rate to bring forward.
I'm not on interest rates, but
Oh, yeah.
I mean, a claimant mightn't like that either because it might say its business had such potential, but for the event,
Right.
sunk costs wouldn't be an adequate remedy, but it'd be a base measure, would it not?
It would be, but then in the actual scenario too, you would need to see if there's still any value to those assets that are there.
Yes. I'm sorry, I was asking you to assume there's no value.
Oh, yes, sorry. Yes. So yes, sunk cost.
Thank you, that's very helpful.
Yeah.
I have a question or a series of questions which are more conceptual or theoretical, if you will. in this case, we have basically three claims: expropriation, breach of fair and equitable treatment, and breach of full protection and security. In the case of expropriation, the standard of value is fair market value at an appropriate date. And this is what you have done, and this is what accuracy has done. So both reports, if I understand correctly, whatever their failures,
Right.
are an attempt to determine the fair market value of the asset at the valuation date, right?
Right.
Okay. And therefore, they respond to the question, what is the valuation in the case of expropriation? Now, let's put that aside. We have two other claims. And let's forget about expropriation for a moment. Let's suppose that it doesn't exist. In the case of claims for other than expropriation, if I recall correctly, the treaty doesn't provide any particular measure of compensation. So the normal way tribunals deal with this is that they go to the standard of wholesale factory with which you are familiar. Now, my question to you is this. Let's assume that there are only two claims, the claim for breach of fair and equitable treatment, the claim for breach of full protection and security. And the standard of the standard of compensation is that of the wholesale factory, which is full compensation, putting the claimant in the same position it would have been in had the breach not occurred. What, if anything, would change in your valuation in this hypothetical scenario?
I would have looked more closely at the discount rate and compared it to the effective interest rate implied on the PLI loan, including the upside participation, which makes it much higher. I would have, because then the discount rate is specific to Lupaka, so I might have increased my discount rate to be higher than the cost of debt, because typically they are. So that's the only change, really, a higher discount rate.
All right. That's all I have. Thank you.
Okay, just so I'm clear, again, this is sort of more of a legal question, but it may be one that is familiar to you. I had understood the doctrinal position to be that in assessing fair market value, you seek to eliminate, insofar as possible, the effects on that value associated with whatever the prescribed conduct by the state might have been. And I thought that was sort of the black letter doctrine here. Do I have that right?
It is, but Mr. Garibaldi's question, as I understood it, was that you wouldn't need to do fair market value. You would base it on Horso. I don't know how to pronounce it.
No, I understand. I was really addressing
okay.
some other questions that were asked. Okay, thank you.
Yeah.
All right. Any further questions from our side? All right. There being none, we thank the experts for their their assistants, and you, ma'am, and Sue, sir, are now excused. So
Thank you.
thank you for your help.
Thank you.
All right, you. All right, you may recall,
Do you think it is possible to recall the other expert to ask this question I asked?
well, I think it's certainly possible. We have the capacity to.
Can we do that?
All right, there has been a suggestion that we might wish to recall the other party's experts in order to address the question that Arbitrator Garibaldi had put. Would that be acceptable to the parties?
Certainly.
All right, gentlemen, can we invite you to come back up? You thought you were free. All right, you can continue to be under your undertaking of as experts, and I ask Ambassador Garibaldi to. I keep trying to promote him, but I think it's a worthy
I've never
promotion.
been an ambassador.
I don't know, you look the part. So over to Arbitrator Garibaldi.
Gentlemen, you have heard my question. Should I restate it?
Yeah, I think that would be helpful. Thank you.
All right. As I understand, the valuation of both experts is based on fair market value, which is the measure of damages in the case of expropriation. Expropriation is one of the three claims basically brought in this proceeding. Let's forget about that one for a moment. The other two claims, the claim for breach of fair and equitable treatment and for breach of full protection and security, so far as I can recall, do not have specifically stated in the treaty a measure of damages, a measure of compensation. In those cases, the standard procedure is for tribunals to apply customary international law, which is reflected in a very old case of the Permanent Court of International Justice, Corso Factory, and the standard that this case adopted is that the measure of compensation is full compensation, which puts the claimant, the successful claimant, in the same position it would have been in had the breach not occurred. Okay, now, so let's assume that this is the measure of compensation for a claim for breach of fair and equitable treatment, or for breach of full protection and security. My question then is, to what extent, if any, your calculation of damages should be changed to account for these two claims as distinguished from the claim for expropriation? Thanks.
From my perspective, we would largely agree with Alex Partners that the distinction is you're moving from a transaction between a hypothetical buyer and seller to a valuation standard that is specific to claimant. So you might look to make some adjustments to the discount rate. But we did, in fact, already model the full costs of the PLI loan anyway, assuming that a hypothetical investor would have taken those on.
Well, you have to explain a little more for my own benefit why you need to change, or in what, no, not why, but in what sense, what do you mean by saying that you need to change the discount rate?
So the way we've built up the cost of equity is based on an average investor in the mining sector in Peru, with an adjustment we've made for the specific status of the project, so the pre-production premium. There may be factors that are specific to claimant that distinguish it from average market participants, which would require further adjustment. but it's not something we've looked into.
Oh, I understand that you haven't, but do you agree that the discount rate would be higher, or you think that it might be lower, or you don't know at this point without going through the calculations?
I don't know at this point.
All right, thank you.
But just so I understand, that the reason being that we're now in a transaction involving a particular party as opposed to the market generically. So that's the point. You need to have reflect a discount rate that reflects the characteristics of this particular party.
Yeah, more or less, with the qualification that you're no longer in a transaction situation. You're really considering the benefits that would have accrued to claimant in a hypothetical scenario but for the breaches.
Gentlemen, thank you. You are again released.
Thank you.
All right, that's been helpful. All right, now, as I mentioned at the beginning of the day, the tribunal will be convening conceivably later today, but certainly tomorrow morning, to discuss a variety of subjects, to include the guidance we would like to give you with respect to the post-hearing submissions. And I invited you to give us your thoughts this afternoon on what you would regard as most useful in the post-hearing submissions. I wonder, are we in a position to do that at this point? I know the schedule is a little different than we might have envisioned. Claimants, are you able to do that?
Yes, sir.
Respondent? Okay. Well, I want to make clear that we are simply seeking your input to assist us in developing whatever order we generate with respect to the post-hearing submission. So with that background, let's hear from the claimants.
Thank you, Mr. President. You referred earlier to the nature of the post-hearing brief and to have our comments on that, and we've discussed with the other side what they had in mind. Our position on this is quite clear, and we're mindful of the very lengthy submissions that have already been provided. We wish to be as helpful to the tribunal as possible. We therefore wish to limit our post-hearing submissions to answering the questions that have been posed or that will be posed by the tribunal. Now, we understand our friends on the other side wish to have an opportunity to make further submissions outside the scope of the questions. Now, we're opposed to this, as this would then require a right to respond, which would further add to the time and cost of these proceedings. In fact, we're not just opposed, we're strongly opposed to this. So we would just limit, we would just ask to limit the response to the tribunal's questions. Thank you.
All right, thank you. That's very clear. Let's hear from the respondents.
Thank you, Mr. Chairman. Anticipating this question, yesterday we shared with our colleagues on the other side of the room our thoughts on post-hearing submission. In terms of nature, I can address nature, length, and date. In terms of nature, we believe that the post-hearing submissions should contain two parts. One would be answering questions from the tribunal, and the second part should be open for the party to decide what other additional information it wishes to bring to the attention of the tribunal, but focused on the evidence that has come to light during last week and today. And this is, you may recall, Mr. Chairman, this is something that we had raised during our pre-hearing conference, and we believe that that would be necessary, particularly in the light of the decision by the tribunal to not have closing arguments.
Now, let me just interrupt you. When you say additional information, you mean new evidence, or
No, sir.
simply your analysis of what transpired in the hearing?
It's the latter.
The latter.
And in respect of the comment from a claimant's counsel about a second round, we do not believe that a second round of post-hearing submissions would be necessary. And as the tribunal knows, it is not uncommon to have only a single round of post-hearing submissions. So that would be our strong preference. In terms of length, we had proposed to opposing counsel yesterday that the length be 17,500 words, which roughly come to 50 pages. But we also indicated that that would be subject to the number of questions that we received from the tribunal, as if we get many additional questions, perhaps 50 pages may not be sufficient. And lastly, in terms of date, we had proposed that the submissions be submitted by the end of June, 30 June. Those are the main parts of the proposal that we put to claimants' counsel yesterday.
Thank you for that. Let me invite claimants' views in particular on the 17,500 words and the date. I have this sneaking suspicion that, given a couple of the questions the tribunal may have in mind, we may need a little more than that, but is that consistent with your thinking, or do you have some, putting aside whatever the tribunal may or may not ask you, is that consistent with your thinking or not?
Mr. President, I think that's quite a difficult question to answer, because we just have no idea what the questions are going to be, and what we want to be is as helpful to the tribunal as possible. So we fully trust into the tribunal will provide a adequate page or number limit which concords with the questions that are being asked, and we're in the tribunal's hands in that respect.
All right, thank you. Let me ask my colleagues if either of them have any observations to make here. None from Arbitrator Garibaldi, please.
Sorry, counsel for the claimant, would a single simultaneous exchange cover your first point of objection?
Now, if it was limited to the questions by the tribunal, then we'd be totally fine with that. Now, if they are then going to argue points out of the evidence that has come out of the hearing, I mean, we're opposed to that precisely because we do not want a second round.
Well, there won't be a second round if there's a simultaneous exchange.
They won't, sir, but out of fairness, we would want to be able to respond to that, and that it would lengthen the proceedings even more.
But what about an open opportunity, apart from answering questions, to address the tribunal in no more than 17,000 words? I'd hope in at least 12-point font and not with narrow margins, on the points which you draw together to establish your case after all the evidence. What's unfair about that?
Well, it's very difficult for us to know, because I mean we just don't know what the questions are going to be, and it may be that we
apart
need
from
all
the questions. I said
apart from the
apart
questions.
from questions. Yes.
So that would be 50 pages in addition, also 17,000 words in addition to respond to the other side's new points or new arguments that are being
to
raised.
put your affirmative case. You're the claimants. You say, drawing it all together, this is our case within the four corners. Full stop.
Thank you, Mr. Griffith. If that is the case, then I think the way to proceed may be instead to have a page limit for the whole, so that we would, because 50 pages just on the evidence that has arisen from this hearing seems rather a lot.
I'm sorry, can I break off there? It's not questions that have arisen from the hearing. The function of hearings nowadays is to give an opportunity to cross. With what your written skeleton, which we've read, the function of the hearing is to give an opportunity to cross and re-examine. So what my inquiry is whether or not it's appropriate to have an opportunity to assist the tribunal by pulling your final case together.
Now, if the parties wish to do that within Just going back on my prior submission, if the tribunal is minded to allow that, then we would agree with the other side in that there should be a 17,500, I think it was, word limit total to
Why not,
answer.
when it's fresh in your mind, we have a limit of the end of May rather than June? We don't want to haunt you by it through the summer. Why not? You've got 7 weeks or so. Isn't that enough? Everything's in now.
Now, this just depends on the nature of the question, because some of the team is unavailable. Now,
It's not summer yet. Your duty is to be available.
in particular, a hearing that's coming up in the next week, so it just depends on the nature of the questions. If the questions do not touch upon sort of the knowledge of some of the team members, then end of May may well be a good time. Is that a time that
Well,
would
it's
be
not for me to
convenient?
bargain, but could you agree to, if we aim for the end of May, and you can make application if you wish a longer period to apply to both parties?
Certainly, sir.
Okay. And the last question I have is, would the parties be content to have an award other than on costs, so that they can frame their submissions on costs, knowing what the result is?
Yes, that would be helpful.
Our view on costs, Mr. Griffith, is that there may be no need to wait for the award before submission of cost is made. If we are allowed a month after we submit our post-hearing submission, as at that point we will have full accounting. We can present submission on costs. If additional issues come up, for instance, the tribunal in its deliberations decides that it wants a joint valuation report, which happens from time to time. At that point, we could submit a second cost submission to supplement the first one. But we are in your hands, in the hands of the tribunal. If you prefer to have a cost submission after you issue an award, then we would do that.
Well, Council, I'm just a winger, but more often than not, one has submissions of costs that are tailored to success on issues. And if you had 40% of the hearing on a matter where the successful claimant was unsuccessful, as night follows day, we'd have long submissions on the usual basis to apportion costs over issues. Isn't it better to know where you are rather than to do the full Monty, as the English call it, and make submissions on every permutation?
We are in your hands, Mr. Griffin,
And
in the hands of the tribunal.
I think the tribunal will consult on this, and let me just ask: has there been any exchange between the parties on the question of
Last time.
sequence and timing on costs, or are we
None, sir.
none? Fine, that's fine. All right. Well, the tribunal will take this up and give you the benefit of our wisdom, such as it may be. But I would only end this conversation with the admonition that whatever else happens in these post-hearing submissions, we do not need to hear yet again the sort of underlying motif of your respective cases. And we've heard it, we know it, we don't need to hear it again. All right, let me ask any concluding observations. There being, please.
We have one request for guidance, and it concerns the issue that the tribunal raised on day 4, but also earlier today, as to the exhibits that pertained to the authority that settles any dispute between rural communities, or the boundaries between rural communities. You had instructed us to make a submission on that point, and we wish to know whether it's a submission that we need to put in writing, we can make verbally. We have consulted with the opposing counsel on this issue earlier today, so I just wish to know how you wish us to approach that issue. And this is in response to Mr. Garibaldi's question.
Well, I had understood you were going to give us a document listing additional legal authorities that you regarded as relevant to this question, with an explanation as to why you thought them to be relevant. Have we understood this in some different sense?
No, that is correct. You had invited us to consult with opposing counsel, and we have. And so my question is, how
And do we have an agreement or not?
So we have looked at the document during the course of the day. In fact, there are two documents. There's a law which has been provided, which we agree can enter the record. And there's also a judicial decision which we consider to be irrelevant. But we're not opposed to it being included in the record if the other side so wishes.
All right, then let me propose that we go ahead and put those in.
Okay.
Is there more to be discussed here?
Yes, sir, if you just
Okay.
just one further point. Now, we've been provided this in the middle of this morning. We've tried to have a look, and we're not in a position yet to say this fully answers or fully sets out the regulation or the law on this issue of demarcation. Now, and we don't actually know if there is anything else. Now, we'd just like to reserve the right to provide or to consult the other side as to whether there is any additional legal authority that needs to be submitted, and if so, and if the other side doesn't agree, then we suggest proceeding in the same way, providing a list, and the tribunal can rule.
All right, well, if you find the smoking transit, you will consult as you suggest, and then proceed along those lines. That seems reasonable enough.
May I add one point? Just to remind you that what I was interested in is the authorities, if any, in Peru that deal with 1, adjudication, 2, mediation of territorial disputes between or among rural communities. Thank you.
We're all clear on that, I think so.
Thank you.
Okay. Is there anything further we need to do at this stage?
Yeah, just one further point.
All right.
This morning, the respondent submitted an additional translation. It was R127, or rather an additional correction to the same translation. Now, we've briefly had a look. We don't agree with some of the changes that have been made, and we're wondering how to proceed. There are a couple of ways in which we could proceed. We could provide our own translation. We could discuss our points of disagreement with the other side. We're
your version of the appropriate translation, and the tribunal will look at them and decide, calling on the expertise and in particular of arbitrator Garibaldi. Would that be acceptable?
Yes. Thank you.
Let's do it that way then. Any other lingering issues? If not, it only falls to me to thank everyone for an excellent hearing. It's been, I think, very educational for us. It is a interesting and in many ways complicated and difficult case, and so you have not given us an easy job. But we have appreciated the help you have given us. We thank you. Wish those of you who are traveling safe journey home or to wherever your next destination may be. So we thank you, and barring any last procedural developments, going once, going twice, the hearing is closed.
Thank you.